So today we're going to be talking about distribution of spousal property. And my presentation is chiefly on case law. So forgive me for taking you through a whole journey through our case law, but I wanted us to think about, does this work? Well, so brief history, because I have 10 minutes to go through what is easily a 3-hour class. So I like to break down our case law into phases. So we have pre-1993, and briefly, we have 2 phases pre-1993, and I'll explain why 93 is the key point. It is because of our Constitution. So when I say pre-1993, means every case decided here was done before we had the benefit of our 1992 Constitution and the protections that it has for us. So under customary law, the position that was espoused in Corte and Marte was that the wife was required to support her husband in the station of life that he was in his profession. And whatever she did not then create some proprietary interests for her. So you help your husband to toil, to do farms, build houses. It all becomes the self-acquired property of the husband. Your labor is what is expected of you as a good wife at custom. And so this position actually, if I'm not mistaken, it was not until Corton and Corton, which is 2012, which was expressly overruled. Everybody else sort of glossed over Corte and Marte, but it was only Corton and Corton that I found that expressly said Corte and Marte should not ever come up again. So it was a very influential case, and it tainted the course of our It tainted the course of our development, right? So what happened was that the interesting thing I found in Owusu and Nyako was that concubines appear to be even better protected than wives were, because there was no duty on a concubine to help a lover in the course of his livelihood, his job. That one, she's a concubine. But the wife is mandated to support her husband. And so in Owusu and Nyako, the concubine actually got 1/3 of the cocoa farms that she had helped her boyfriend to toil on, whereas in Corte and Marte, the wife didn't get that. So this was the rather absurd situation that our interpretation of the roles and duties of wives and husbands at custom created in Corte and Marte. To get away from Corte and Marte, because increasingly women were bringing on more than physical labor, and the courts did not see how to keep women in that same place. I'm bringing money now. I'm coming out. I'm also bringing capital. We are doing the business together. You are saying that the money I brought is your money because somehow it's all been merged and you are the one who gets the benefit. So the courts were faced with a number of wives who were exceeding the Corte and Marte threshold, herein after QVM threshold. And so we have what developed as the substantial contribution doctrine, right? Which essentially, and initially they were saying substantial contribution, but by a time point, we knew the truth. It was financial contribution. Once you brought money on board, the courts could not look at you as the same kind of wife that was seen in Corte and Marte. And indeed, the courts did not think that customary law envisaged a wife who was bringing money. And therefore, if you brought money on board, you had gone beyond what was expected of you at custom and deserved special protection. Then, for that, we have the substantial contribution doctrine. You had to prove either you brought money or there was an agreement that was capable of monetary terms. So if you agreed with your husband that you wouldn't go to work, so I'm qualified as a lawyer, and I say, well, because of whatever reason, we agree that I won't go to work, my husband will be the one to provide. That agreement is capable of a monetary value because I can calculate how much I would be earning with my qualifications. If you could put yourself in those categories, then the court was moved to help you to get something. And one of the biggest cases there, Bresa and Car, it's interesting because it's often repeated and oft-cited that the ordinary incidents of commerce are not expected in a marital relationship, which is essentially to say that just because a woman cannot prove receipts doesn't mean necessarily that she wouldn't get anything. My mother always says women's money tends to buy things that don't have receipts, garden eggs, tomatoes. Nobody gives you receipts for those. But unfortunately, typically the case you see, that's where their money was going. And so the courts were moved to support them because although they could not quantify sometimes exactly how much they brought, there was clear evidence that these people were capable of bringing money on board. So keep that in mind. Next slide, please. So for context, and I know my brother Chumesi will go into more detail in the law, so just to give you context. After these cases, we had the Constitution, and in particular, Article 22, and of interest for me is Article 22(3). And the essence of it is that the law was looking to a space where spouses would have equal access to property jointly acquired during marriage, and when the marriage was over, when it had gone south, that the properties that were acquired jointly during the marriage was to be distributed equitably. So when you are together and we are all happy and smiling, it's equally. When the smiles have turned to frowns, now we're doing equity. So what is equitable as between the parties is what the court was mandated to do. Prior to that, we had Section 20 of the Matrimonial Causes Act 1931, Act 367, which gives the court the power to convey, to order a party to pay money or to even give property as part of the post-divorce distribution of properties, right? And again, it was as the court thinks just and equitable. Before 1993, just and equitable depended on substantial contribution doctrine because it was unjust if you brought money. After 1993, the tenor of that language also began to change. So let's look at what happened post-1993. So here, again, for the purpose of digesting it a little easier, I have it in phases. So post-93A, the case law that you find typically relied on equity as a guide, so maxims or principles of equity, but you could also see ghosts of the substantial contribution doctrine haunting the hallowed hallways of the, alliteration, the hallowed hallways of the courtrooms. So you had Mensa and Mensa, the first Mensa and Mensa, not to be confused with Gladys Mensa and Stephen Mensa, which I'm sure a lot of people have heard of, where Bamford Addo JSC, as he then was, relied on the maxim equality is equity, and chiefly looked at intention as the major indicator. So in this case, it was actually the husband who was seeking the property, and in the trial court, they had done some kind of half and half. Well, you built the main, you built the extension, so this one belongs to this one belongs to this one. And when it got to the Supreme Court, Her Ladyship said, we can't do this piecemeal half and half sharing. When the parties cohabit and then they live, they reside in that house in a manner that shows that they didn't intend for it to be splitting it up into little pieces. You should use their intention. So the intention of the parties at all times, in this case, was that they should use it together and therefore own it together. That would have been perfect if she had remained there, except that she went back into Achampo and Achampo, which, as we have said, belonged to the substantial contribution doctrine area. So in the early days after the Constitution, there was still some sort of reversion to the old language of the contribution. So she went back to look at, you brought money, I also brought money, and so we have contributed and all that. We had the same problem in Do and Okuku Ansa, where again, the majority of the court went back to the language of substantial contribution. So once again, looking at if you brought money, although we had moved into a new era by that time, we were still holding on to the unfortunate element of the past. Unfortunate because it's not every woman who had money. And if you didn't have money, you went back to Court and Marty. In the phase 2, after 1993, you have the courts now looking to the Constitution for the solution. No longer equitable principles, but now looking at what does the Constitution say and attempting to interpret the Constitution to determine property rights. So seminal, and there are many cases here, so I only picked what I thought was seminal. Boafo and Boafo, you'll see it cited in almost every case after it was decided. I have many problems with that case, but I limited myself to this one here, which is emboldened. But in Boafo and Boafo, the Teba JSCS then says the question of what is equitable in essence, what is just, reasonable, and accords with common sense and fair play is a pure question of fact dependent purely upon the circumstances of the case. So in Boafo and Boafo, there was this attempt to explain what the Constitution meant by equitable access to property. And he says, he constructs that meaning within the sense of just, reasonable, common sense, and fair play. My challenge with this common sense bit is, as I'm sure you can imagine, common sense does tend to vary. And even on a panel of the most eminent justices, they won't agree on what is common sense all the time. So I find that standard a bit difficult to apply on a practical basis. But the more egregious issue for me was that, once again, there was an attempt to return, in a sense, to the SCD language, the substantial contribution language, and then he said, where there's substantial contribution by both spouses, equality as equity will usually be an equitable solution to the distribution issue. Not that he is wrong in that sense, but to go back to that language of substantial contribution, and I hope to be able to prove it to you subsequently, then affected subsequent cases so that there's still, even now, a sense of substantial contribution still following us even today. After this, the next case would be Mensah, Gladys Mensah and Stephen Mensah. Now, I'm told that after this case, a number of people ran to court because they had heard that the courts were now giving 50-50. And so there was a whole rush to court. And after that, you can see that the judges have started to close their floodgates with the way they enunciate principles on distribution. So in Gladys Mensah and Stephen Mensah, we have for the first time the Supreme Court leading the charge to say, we are not looking for money anymore, or not looking just for money. Now, if a woman, we can count childbirth, we can count domestic services, because not everybody works outside of the home. And as we know, we rarely pay, if ever, women who work inside the home as wives. So the court decided that we would look at a new way of explaining contribution so that the work that the person brings to the table, in terms of the housework, the peace of mind that they give so that the man can go and earn his millions outside, should all count as contribution. Courtin and Courtin again repeated this message in Gladys Mensah and Stephen Mensah, and it's important because in the Court of Appeal, 2010, before Mensah and Mensah was decided, the Court of Appeal said they couldn't see how they would value housework. What kind of value would they put to childbirth? So it was interesting that 2 years later, the Supreme Court said they can value it, and it's no problem. And so Courtin went on appeal to the Supreme Court, where we hope that she got a better deal. I have my reservations as to that, but 2 minutes won't give me a chance to give you all of that. So from there, we go to Arthur and Arthur, which is really the starting point, I think, of the contemporary language on property rights. And Arthur and Arthur, now rather than looking at equality or equity as the end, or equality as the end game, the end or the target, now says we should start from equality. So when we go to court, we start on the presumption that marital property, in other words, property that was jointly acquired during the subsistence of the marriage, is to be shared equally. That is our presumption. Then we tweak it depending on the circumstances of the case, because not every case should you get 50-50. Some you should get 60-40, some even 70-30. And so the first thing that Arthur did was to create the presumption that if the property was bought during the subsistence of the marriage, it was marital property. And therefore, it fell to be shared on that basis. But it's a rebuttable presumption, which means that the party who says, no, I bought it by myself, even though I was married, is able to bring evidence to show that it is their self-acquired, individually owned property. And it is important to note this because subsequently in Fin and Fin, the court emphasized that these principles did not come to override Article 18 and give you, and say, oh, well, now you can't own property by yourself anymore. So it is rebuttable. You can bring evidence to show. Next slide, please. Next slide, please. So, general observations. When we say equality is equity, but the equities will decide, we've already explained that to mean that we start from the presumption that we will deal with you equally, because what is equal will be equitable. But if the circumstances suggest to us that equality will actually end up being inequitable, then we will tweak it to suit the circumstances. So where it is clearly unfair to give you 50-50, the court will not give 50-50 just because that's the presumption they begin with. And so the court in Obing explained that yes, they do not really use mathematical formula, but where it is open for them to see clear proportions, they will apply maths. So if it can be 60 and 40, they will do so. And Mensa Bosu and Mensa Bosu 2022, it's so weird to mention my name twice, found that although the cases that are based on the Constitution tend to reflect the Constitution as to where we are going and how we are going for equity, the rhetoric did not always match the outcome. So in an attempt to, I'm working on a paper that is trying to see which of the two factors the court uses creates better outcomes for women, as somebody who writes in gender. And typically, the courts have looked at either the intention of the parties, as I explained earlier with the first Mensa and Mensa, and also contribution of the parties. So the question that I'm asking myself is, which of these has brought better outcomes for women? And it is not a complete picture yet, because I'm still working on it. But what I want to show you, in Mensa and Mensa, when the court used intention, you had the equal-sided arrows are neutral, with each side got essentially 50-50. So neutral gains. In Amapohene and Amapohene, in the Supreme Court, which of course overruled the CA one, but this is just for illustration purposes. Again, you had 50-50 more or less, so again, neutral. When we used contribution in the Court of Appeal, the woman suffered a loss. And so it made me start thinking, is contribution worse or better than intention? Next slide, please. And again, I'm finding that as I'm reading cases, I'm finding what I think looks to be a pattern, although there are some anomalies, that wherever the court was minded to use contribution, the women typically did not fare as well as when they used intention. So again, Do and Opoku Ansa, you have a negative outcome for women. In Nyama, Amposa and Nyama, intention, once again, more or less 50-50. The two cases in the middle, Tabri and Yabuaba, and Eseko and Inkum, Tabri is interesting because she put all the properties in the name of her husband. But she was very fortunate that she could show clear, active participation in the business that the court could not deny her claim. Eseko and Inkum, the arrow is pointing the wrong way, so it should be down. I consider it negative because although the properties were divided equally, the evidence suggested that the woman actually provided far more, because when they first began, it was a one-bedroom house. Because of her, they had 3 bedrooms at the time they were sharing properties. In addition, there was evidence that her husband had been laid off for we don't know how many months in the case, unfortunately, but she was the one who was solely taking care of the husband, the home, the children, everybody. And yet they still gave 50-50. So I think, again, I still find that to be a bit of an unfair balance, considering the court has said that they are willing to use proportions sometimes. I thought that in this case, they ought to have gone proportions. In Nano and Nano, I believe the husband had heard about Mensa and also ran to court, because what women can do, apparently men too can benefit from. And so ran to court and said, I'm married to her, give me some of her things. But he was unable to establish contribution. So the one case where contribution actually worked reverse against the man and to the advantage of the woman. Next slide, please. So, challenges. So far, what I've found is that one of the challenges is that the women keep putting the names of the properties in the names of their husbands alone, or at best, the both of them together. Now, it's an important thing to note because it's a social challenge. It's not necessarily a legal one, but it has legal ramifications. Because when you put somebody else's name on the documentation, you then have a bigger burden to prove that you actually contributed. And it may have been yours. You bought it. So yes, Tebri, she succeeded, but it was not easy for her because then she had to lead evidence to show where her participation was, how active she had been, what kind of money she had brought. If it had just been in her name, it would have been a lot easier. So we have a social problem that is lurking underneath all of these legal issues, where wives are putting the names of their husbands on the documentation rather than their names. If the agenda class would have gone into to think about why, what is the social challenge with that? But we'll leave it there. Again, we have the language of financial contribution coming up again. Fin and Fin is one of those cases where financial contribution came back once again into the language of the courts. So although Mensa and Mensa, that is Mensa, Stephen Mensa says it has sounded the death knell to substantial contribution doctrine, I find that there's still some strains of that doctrine lurking in the language of the courts. Successes. The presumption of marital property, to a large extent, has been a good thing for a lot of women because typically the income is in the hands of the man. Typically, property is in the hands of the man. So the presumption that whatever is acquired during the subsistence of the marriage is marital property has aided some women, not all. As with all things, there will be some women who will be disadvantaged, but it's a start for us to be able to start refining what that looks like. And this presumption has even extended to the Land Act 2020, Act 1036, where in Section 47, you are not allowed to alienate, transfer, convey in any way property without the written consent of your spouse. It is to avoid fin and fin, where a husband sold property that the wife said she was entitled to. She couldn't prove it in the end, but it was to avoid the situation where you'll be sitting in your house one day and somebody will sell it and they'll say, well, your husband said it's his, so he sold it. So now you can't do that under Section 47. Again, as I said, now you have equity as the starting point. Equality is now the starting point and not the end goal. So it is an easier, I think, means of arriving at the equity of the situation rather than trying to reach there as our destination. The last two things I think are really important achievements that the Supreme Court has led us to is the recognition that domestic work, childbirth, etc., all form part of contribution. The downside to this is that perhaps we have also opened the way for husbands to come and say, she didn't do anything. She was never cleaning, I cleaned. She had housekeepers, she had gardeners, she had chefs. So we've also potentially opened that door as well. But I think it is still worth commending and worth commenting that rather than just money, we have looked for other things that the wives can show as contribution. And then, as I said earlier, Corton and Corton finally expressly killed off Corty and Marty, so that hopefully we no longer have to worry about people who don't have money as their contribution or as the evidence of what they brought to the table, to use present-day language. Next slide. I believe this is the end. Yes. Thank you.